I'm going to emphasize my reservations about the paper, but I want to say at the outset that this is a promising project, and I expect it will provide a useful contribution to literature. The paper opens with a strong statement about the revolutionary potential of corpus linguistics and constitutional interpretation. But the authors conclude, as Josh just said, that this new research technique was unable to resolve even the narrow question of whether the Second Amendment protects an individual right or an exclusively collective right. At first blush, the Second Amendment looks like a good test case for the utility of corpus linguistic analysis. There is an obvious puzzle in the constitutional text, which alludes to the importance of a well-regulated militia and then protects a right of the people to be free of some class of regulations. What does the preamble's reference to the importance of a well-regulated militia have to do with the right of the people to keep and bear arms? One usually thinks of constitutional rights as obstacles to regulation, not spurs to regulation. It's not immediately evident how this right to arms could or would contribute to the establishment or preservation of a well-regulated militia. To make things worse, there was not much recorded debate about the amendment in Congress and virtually none in connection with the ratification. Now, linguistic analysis could solve the puzzle if the phrase keep and bear arms had a technical or idiomatic meaning. A quarter of a century ago, Gary Wills argued for just this solution, relying primarily on sources written in Latin, which is something Justice Stevens does too, but Wills did it much more elaborately. He's relying on sources written in Latin, and he concluded that to keep and bear is a description of one connected process which referred to the militia's permanent readiness. But Wills did not produce even a single example of the phrase being used in that way in the English language, which suggested to some of us that he was guilty of a peculiarly perverse form of law office history. Now, Blackman and Phillips confirmed that Wills would not have been able to support his theory or anything like it if he had done more research. And that, I think, is the paper's most significant finding. But that leaves open the possibility that the Second Amendment protects only a right to keep and bear arms in connection with an individual's malicious service. In other words, the language of the amendment, the words of the amendment, do not rule out the possibility that the Second Amendment right is one that can be exercised by the people only through some form of government action, presumably action by a state government. That interpretation of the amendment is at least suggested by its opening phrase, a well-regulated militia being necessary to the security of a free state. Now, I don't think anyone would doubt that the individuals who constitute the people could keep arms in a central arsenal under the control of their state government or in their own homes pursuant to that government's command or pursuant to a license from the government. Nor could anyone doubt that the individuals who constitute the people can bear arms when performing malicious service. The amendment, therefore, could be referring to a so-called collective right if one means by that term a right to do only what the government orders you to do or authorizes you to do. I think that would be a unique kind of constitutional right, certainly a rather strange one, but that does not mean that it's a linguistic impossibility. Now, Blackman and Phillips used corpus linguistics to confirm that this collective right interpretation, which is adopted by Stevens, is linguistically possible. They also confirmed that the alternative interpretation, according to which the Second Amendment right is one that attaches directly to individuals, is also possible. I think it's useful to learn that corpus linguistics does not rule out either of these interpretations. But I think this merely confirms what was already very clear to everyone who had studied the sources that were widely known before corpus linguistics came along. Now, that's not a criticism of the paper. It has recently become notorious that too few scientific experiments are subjected to the test of replication. Similarly, it's valuable valuable to find that corpus linguistics can confirm conclusions that have previously been reached on the basis of more limited evidence. Still, I suspect that the Blackman and Phillips paper says more about the limitations of corpus linguistics than about its revolutionary potential. The authors acknowledge that other kinds of evidence are relevant in interpreting the Constitution, but they do not stress that point as much as I would. If it were my paper, I'd be inclined to flesh it out in one of two ways. First, I might discuss the textual and historical evidence that bears on the collective versus individual right issue. There's actually quite a bit of such evidence, and it's been pretty thoroughly discussed in the existing literature. I think this evidence actually does provide an answer to the important questions that corpus linguistics cannot answer. The paper would then be a cautionary tale about expecting too much from this shiny new research tool. Alternatively, the authors might consider finding a different constitutional provision where corpus linguistics really can add a lot to what could have been discovered before that tool became available. Perhaps the emoluments clause, which Blackman and Phillips mentioned, is such a provision. I don't know about that. If they could explain why the new tool had more power in one case than the other, that might be helpful in predicting when corpus linguistics is likely to be worth a researcher's time. Now, I do have one quibble with the author's substantive analysis. They conclude that the Second Amendment cannot be read to refer solely to an individual right, and they base that conclusion entirely on the fact that the term bear arms is most often used in what they call a militia or collective sense. By militia, I think they meant military, so a military or collective sense. Now, that's a tempting inference, but it's not a necessary inference. It's possible to interpret the Second Amendment as protecting an individual right that happens to have what the framers considered to be healthy or desirable effects on the militia and thus on the people's collective security. I believe that's the correct interpretation, but whether it's correct or not depends on evidence and argument that is outside the purview of corpus linguistics, and so I don't think that it was refuted in this paper. One additional small point, the paper uses two technical terms in ways that confuse me, namely lemma and null hypothesis. I think the authors may have used those terms incorrectly, so I would recommend that they double-check their usage. And those are my comments. Thank you.
Nelson, I agree. When I walked into this paper, I was like, shiny new tool. And then when I walked up, like, okay, that didn't really do much. But I think that is itself valuable. We tried to replicate stuff people have done before. We were able to replicate it. And we're not making any bold, daring conclusions, which I think makes us more believable and palatable. And the fact that we haven't used it here, it does think bolster. Now, James wrote a very powerful study on the emoluments clause, and now other scholars have written contrary studies on the emoluments clause of the corpus linguistics, so we have debates elsewhere. But I think the reason why the Second Amendment is so hard is because of the grammar. You have the prefatory clause, you have the operative clause, you have the keep arms, the bear arms, you have the right of the people. There's a lot going on, and I think it's a pretty weak candidate for CL. And I should just note that Nelson was my professor, and actually I worked with him on his Heller amicus brief, so this is sort of a cool experience, and it's now a decade later. So thank you very much, Nelson.